the future. My name is Mike Caldwell, and I'm currently the manager of estate gift planning and also one of the staff liaisons for the Always United group. Before introducing our guest speakers for today's webinar, I'd like to just make a few comments about what has led up to today's topic. There's no question that the last 22 to 23 months have been arguably the roughest period of time many of us have been through or ever experienced. And while we're not out of the woods yet, I would like to believe that we're getting close to an end. And first of all, to all of our donors on this call, I want to thank you so much for your support during this period of time. We've been working really hard at United Way to put your gifts and contributions to work. And while it's been quite an adjustment for all of us while working remotely, I'm proud to report that our staff didn't miss a beat. For example, last year, United Way awarded $7.5 million worth of grants last year to 25 different organizations to support our family opportunity programs, one of the 3 initiatives aimed at reducing generational poverty in Central Indiana. 14 nonprofits received $1.2 million in grants from our Social Innovation Fund, which is designed to support nonprofits that are developing creative solutions to address needs in our community. Roughly 5,000 people were assisted because of this funding. We also granted a little over $10.5 million in basic needs fund grants to 63 different organizations, which helps thousands of children, families, and individuals gain access to nutritious food, safe and affordable housing, healthcare services, and transportation in Central Indiana. We also announced and implemented a joint investment of $500,000 to launch a planning process to create the Indy Summer Learning Labs. Our city's students, families, and educators deserve community investment to create access to high-quality summer programming for those that need it most, and this joint investment with Mind Trust accomplished that goal. United Way also awarded almost $2 million to organizations, different nonprofits in Boone, Hamilton, Hancock, Hendricks, and Morgan counties to help meet the needs affected by the pandemic. So as you can see, we've been busy, and there's always more work to be done. So again, thank you for all your donations and the investment in United Way to help us make this happen. So at this time, let's get on with our webinar, and I'll turn it over to another staff liaison of Always United, John Towle, who will introduce our speakers for today.
Thank you, Mike. Hey, everyone. Like Mike said, my name is John Towle, and I'm a leadership giving manager here at United Way of Central Indiana. I work alongside Mike in assisting with Always United with our Forever United network. And I want to echo Mike and just say thank you to all of you for attending. And I'm happy to introduce our 2 wonderful speakers this morning. First, I'd like to introduce Greg Pemberton. Greg is a longtime volunteer for United Way of Central Indiana. He served on the board of directors, chaired the investment endowment committee, taught in the Volunteer Action Center as part of the Art of the Bark series, and served as the last chair of the Community Service Council. In addition to United Way, Greg has served on the boards of the American Cancer Society, the Indiana State Museum and Historic Sites, the Hoosier Salon Patrons Association, the New World Youth Symphony, the Council of American Bar Association Health Law Section, and the Walter Cancer Foundation. Greg is a retired partner at the law firm of Ice Miller LLP and has spoken and written on the topics of board governance, fiduciary duties, tax and regulatory issues, and volunteer immunity and liability. He can also be seen most Sunday mornings playing bass guitar in the Orchard Park Presbyterian Church, Indianapolis Praise Band. Thank you, Greg, for being here. Our second guest speaker is Lisa Dillman. Lisa has been practicing law for more than 20 years, the first 10 of which were spent in the courtroom fighting for her clients' rights, and she uses that experience to now advocate for Applegate and Dillman elder law clients. She's a certified civil mediator and practices in the areas of family law, guardianships, probate administration, and litigation. Her vast litigation and appellate experience were developed through numerous bench and jury trials, court hearings and appeals to the Indiana Court of Appeals, Indiana Supreme Court, and United States Circuit's Court of Appeal. Lisa is also a member of the Elder Law Section of the Indiana State Bar Association and chairs the Veterans Affairs Committee. She is a member of the National Academy of Elder Lawyers and Elder Council, and additionally, she has been involved with Meals on Wheels of Central Indiana for years and is now the chair of their board of directors. In her spare time, you'll find Lisa spending time with her daughters and her husband, and she also loves gardening, kayaking, and reading historical fiction and nonfiction. Again, thank you both, Greg and Lisa, for being here. We're delighted to have you here this morning, and now I'll pass it off to you for our webinar.
You are all very lucky, but in full disclosure, I'm comic relief this morning. Your real substantive expert is Lisa Dillman. She's a very qualified, very talented lawyer with great experience in the topic that we're about to discuss today. And with that, Lisa, I turned over with great deference. Please proceed.
Well, thank you, Greg. I'm going to share my screen. I have a short slide deck that kind of helps walk through these topics of planning and kind of what elder law is, and you'd be surprised. I do a lot of speaking engagements with lawyers who are not elder law attorneys, and we come away from those sessions with them concluding that they might be practicing elder law and not even know it. So these topics that we're going to be talking about today are really pervasive in our community, and I would venture to say touches a lot of us in our own personal lives, as well as, of course, my professional life. But let me just kind of tell you what an elder law practice is. It's essentially my job on a day-to-day basis is to meet with clients and their families, because these plans do impact families often, to develop a future plan to pay for care with the least financial impact. So we want to make sure that our plan takes into account what we know may happen, or at least statistically may happen as we age. I will tell you, when I started, I did want to comment. I made a note when you read my bio. I think it's a little out of date. I've been practicing for nearly 30 years, but I shouldn't confess that. But this slide makes me ponder that experience, because when I first started doing elder law and planning, I believed, or I thought, that the plans emanate from the legal side. But as I've grown, I've learned that the legal side is maybe the smallest cog in the wheel. The largest cog in the wheel, or what drives the need to plan, are social issues, are medical issues that kind of dovetail into financial issues. And then finally, you need a lawyer. So I like to try to approach the planning platform from where is the person and where is their family now, socially, medically, what kind of future are they looking at, and what kind of supports do they have in place financially and legally. So let's first talk about the most basic set of planning that you could do. I kind of like to look at the planning analysis in kind of a three-phase program, or a three-phase kind of flow chart. Number one, what are the basic legal documents that every single person needs, irrespective of age, irrespective of medical condition? And COVID, like Mike mentioned, COVID really drove this lesson home. It doesn't matter if you're 25 or 85. There are a few legal documents that you have to have in your strong box or in your filing cabinet. And if we were all together, I would take a poll by show of hands, what folks thought were the most important legal documents you could have in your filing cabinet. And I'll tell you, when we were doing live programs, most people raise their hand and say a will or a living will. And I find that sometimes people are surprised to learn that, in my humble opinion, the most important document you can have in your filing cabinet is a power of attorney, a financial power of attorney. More expansively, a set of what we call advance directives. And advance directives are it's just a fancy schmancy legal term for a set of powers of attorney, essentially. These are documents that give you a chance to give your directions in advance, so that your family or your friends, loved ones are not guessing what you wanted or what you intended if you're not able to speak for yourself. So what's essentially contained in a package of advance directives are a general durable power of attorney, which, like I said, deals mostly with finance, a healthcare directive, which some folks, some practitioners, and you may have these documents in your files, some practitioners conflate or mush together the financial power of attorney with the healthcare power of attorney. We like to keep them separate for a couple reasons. Number one, it's not the bank teller's business what you would like to do with your healthcare, and it's not the nurse practitioner's business what you'd like to do with your finances. So we like to keep those separate, but also the legislation, the laws that are passed in the state of Indiana are passed, they're not linked together. There are laws and rules that deal with financial powers of attorney, and that there were laws and rules that deal with the healthcare powers of attorney. So those are the main two headliners in a package of advanced directives: financial power of attorney, healthcare power of attorney. We also have a document called a HIPAA release of information that supports the healthcare power of attorney by essentially listing out who you would give permission to talk to a doctor or to review a medical record, to pick up your prescriptions, those kinds of things. The fourth document that we have in that package is a living will. A living will deals only with end-of-life decisions. So if a physician certifies that death is imminent and the only thing keeping you, sustaining you is artificial means, then this living will lets you have an opportunity to direct how you would like your care to go at that point in your life. The fifth document that we like to include in the package of advanced directives is what we call a funeral declaration. And that just gives you an opportunity to kind of lay out what kind of arrangements you would like to have made, or what kind of arrangements you've already made, and provide kind of instruction to your loved ones or your designee of where to get this information so that your wishes could be carried out. The most important decision in that funeral declaration is centers on disposition of remains. Do you want to be buried? Do you want to be cremated? It's that decision that seems to trigger the most controversy in families. That no, mom didn't want to be cremated, I promise. She told me so. Well, she told me last Thanksgiving that she did want to be cremated. So if you can execute a document like that gives your family some peace of mind and direction on a really critical and very emotional decision, that's quite helpful as well. I should have launched out in the beginning of the program by saying I'm one of those kinds of speakers that if you have a question that's relevant to what we're talking about or timely to the subject matter, go ahead and pop in with your questions. I feel like people learn more and get more when it's kind of relevant in real life. And then of course I know we have time at the end for questions if you'd rather save them. So this.
Sorry, we actually do have a question that just popped up in the chat. And it is healthcare representative appointment the same thing as healthcare POA?
Yes, it is. It is. You'll find that there are several names in the industry, different lingo. But yeah, if you're talking about giving your directions in advance, you're talking about giving somebody the power of attorney, or allowing somebody to step in your shoes as your fiduciary. And I know, Greg, you have immense experience in fiduciary responsibility, in choosing a fiduciary, so you feel free to chime in too as we proceed.
Will do, Lisa, thanks.
Sure. What is the consequence of not having advanced directives? If you have not designated somebody to speak on your behalf, if you're not able to, then, and that situation comes up, I'm walk out and get in a car accident today, and I would absolutely rely on my power of attorney to make personal decisions, professional decisions to a certain extent. I need somebody to conduct the business of me if I am not able to conduct that business. If I do not have that power of attorney in place, then my loved one has to go down to guardianship court and receive a guardianship over me. That is not ideal. If we can avoid guardianship, we would absolutely like to do it. Number one, a guardianship proceeding is a public proceeding. It's filed in a court of law, and many of those filings are reviewable to the general public with very little effort. And keep in mind that one of the threshold issues that is proven down in guardianship court before you're able to get a guardianship is that I'm not competent, that I lack capacity. And that's a very personal, private thing that is not ideal to be spread out into the community at large. Guardianship is much more expensive. For the price of a very robust set of advanced directives, you're probably going to pay that for the first hour of your guardianship attorney's time down in guardianship court. So, I mean, because obviously some lawyer wrote the guardianship legislation that you are required to be represented by a lawyer in front of the guardianship court until excused otherwise. So it's just a better use of your resources to go ahead and put that private, customized advanced directive in place. The other thing that's nerve-wracking and kind of scary about a guardianship court proceeding is that it's uncertain. When I execute my advanced directives in front of a notary, I know that there's legal teeth that will enforce my advanced directive. But if I don't have that in place, it's the guardianship judge's judgment that replaces mine. So, perfect example, if I have been taking care of my mother for years and years and years, and she just failed to get advanced directives in place, and now I need to get a guardianship, I will go down to guardianship court and say, hey, I'd like to apply to be my mother's guardian. And anyone else can apply to be her guardian as well. So my estranged brother could come in and get that position instead. I know that's not what my mother wants. I know that's not in my mother's best interest, but the judge may not know our scenario as intimately as my mother would have chosen. I should say my brother and I are not estranged. I don't have guardianship of my brother, just in case I'm starting nasty rumors. The other thing is the guardianship court requires a supervise. They supervise expenditures that you're making on behalf of the ward. They can restrict expenditures. You may want to do a remodel in the house to put a ramp on, or a wheelchair accessible shower or something. And if the guardianship court thinks that's an expenditure of too much of the ward's money, they could say no. So I think you're getting the flavor of my soapbox speech that it's so much better to control it yourself in a private forum. It's more economical, and you can customize it to however you see fit. If you don't want your power of attorney to become effective until a doctor says you are incapacitated, you can have it that way. You can say that it becomes effective on your 85th birthday. You can say whatever you want. There are no rules with respect to how you want to fashion your wishes. And that it's that impact right there that makes advanced directives more attractive than guardianship court. I throw this question in here, not so much because you may be pondering it, but because it comes up a lot in my practice. And that is, I will ask my clients, would you like to execute a living will, which again governs end of life decisions. And many clients will say, no worries, I already have a do not resuscitate order or a DNR. There's a very critical difference between a DNR and a living will that I think it's important that we all understand. And that is, a do not resuscitate order governs all of the care that's given prior to that physician, that attending physician certifying that you are at end of life. That means your DNR will be read and followed by a first responder, by a paramedic, by a triage healthcare provider in the ER. So if your DNR says, please do not do any artificial means, do not take extraordinary efforts, you may not reach that physician to certify that you truly are end of life. So a lot of folks, that they don't realize that that the DNR will be followed even before a physician has weighed in on this particular medical event, which may be fine. And DNRs are very widely used for folks with terminal conditions that are frequently taken to ER, and they've been around the block on this issue before, and they know, hey, I really do not want any extraordinary measures. So I'm not advocating that you choose one way or the other. I'm just advocating that you know the difference between what a DNR covers and what a living will covers.
Hey, Lisa, we have another question that popped in. Are the advanced directives prepared in Indiana valid in other states if you move?
Absolutely good question. In fact, I have that later in the process. That's a fantastic question. And here's the lawyer answer. You're going to love it, and at the same time, pull your hair out. It depends what kind of advanced directive that you have. And we have, I create advanced directives that do not cite to a state-specific statute. That's why the advanced directive is 35 pages long, because we write out what the advanced directive is. So with the eye toward it being portable, that it can be with you when you winter in Arizona. It can be with you when you're on vacation visiting your family in Oregon. That being said, even if your power of attorney itself is portable and not Indiana specific, it still is being read by the folks who are in that locale where you seek to use it. So if you have declared something in your advanced directive that is absolutely legal in Indiana, but not legal in Oregon, like perhaps there are states that do not allow you to decline artificial measures at the end. Maybe they don't allow you to decline nutrition or hydration. Some of your choices may not be enforceable in that locale, but if you get the right kind of advanced directive, it should at least be portable state to state. That being said, you leave the country, all bets are off. There's no guarantee that those advanced directives would hold sway in foreign jurisdictions. Where that really has come into play, and has come into play in my practice, is what is a cruise ship? what jurisdiction is that in? And we have to assume that that is going to be outside the jurisdiction of the United States. So advanced directives, they do have limitations at that point. Oh, I think I already touched on this when I talked about the funeral declaration. Just that funeral declaration, a lot of people will shy away from that. And I know personally I'm in the same boat. I have not made those arrangements, those decisions yet. I just encourage people, if you know just the disposition question, if you know the answer to that question, that document may be worth executing just for that reason, in case something would happen kind of prematurely. All right, that's phase one, advanced directives, avoiding the consequence of guardianship. Phase two of the planning will answer the question of what happens to my stuff upon my death. And then that begs a myriad of questions of, do I need a will? Do I need a trust? Do I need either one of those things? I think the best starting point to begin to analyze that question for your particular situation is, what's the difference between a will and a trust? A will is a written set of instructions of what to do with your assets and with your property upon your death, but so is a trust. A trust is a written set of instructions of what to do upon your death. So what gives? I will tell you there's maybe a preconceived notion that if you are not a very high net worth individual, you don't need a trust, because a trust only is needed if you have a lot of money. That is not true. Let me tell you the difference between a will and a trust. If you have assets that will pass to the next generation pursuant to your will, those assets will have to be administered by the probate court judge. If you have assets that are in your trust, those assets can be distributed to the next generation with no probate administration. A lot of people do not know that. A lot of people think I have a will, I'm protected, I'm fine. But the reason that your estate, if you have a will-based plan, that your estate would go down to probate court is because, perfect example, let's say I own my home is titled in my name only, I pass away. There is no one alive anymore who can sign the deed to sell my house or to give my house to my children. The only person with the legal authority to sign that deed is the probate court judge. That person is the only person that can legally delegate that duty. So that's why assets in the decedent's name only have to be probated down at the probate court, which if we can avoid probate, I would like to, because assets that go through probate, they're public, and it's just more costly. You need a lawyer, there's going to be exposure to creditors, those kinds of things. So on average, to probate an estate, it usually costs anywhere between 4 and 11% of the estate assets, depending on what counsel you have taking your estate through probate. So when you monetize that or quantify that, you may spend better money, smarter money, creating a really simple trust-based plan that allows you to avoid that process. I also say that the rule of thumb is if you hold your wealth in a complex manner, meaning that it's more than just a house and some bank accounts, let's say you have some mineral rights or some royalties or any business interest, or let's say you share some ownership with your siblings of mom and dad's farmland or something like that. If you hold your wealth with any sort of complexity, I automatically start at least analyzing the situation through a trust, even if it's not a lot of assets, but if there's some complexity. The other thing is, if you wish to do more complex things with your property upon death, charitable giving, you have special needs loved ones, you want to leave specific instructions with respect to your business interests, those kinds of things, I also say a trust is probably best. Let's do an example where I might recommend that neither a trust or a will is necessary. What kind of plan is that? Well, Indiana is a state that in the recent years has enabled or enacted transfer on death laws that really help Hoosiers distribute their assets without the need of probate, and maybe without even the need of a trust. What does a transfer on death plan look like? The rule is, if there are any assets that are left after death that do not have a designation, an automatic transfer upon my death, those are the assets that'll go through probate. So if I can, let's say I hold my wealth this way. I have a house, I have an IRA, and I have a life insurance policy. My house can have what's called a transfer on death deed, meaning as soon as I die, it automatically transfers to my children. I don't need the probate court judge. My IRA has a beneficiary that as soon as I die, it would go to my children. I don't need a probate court judge for that asset either. And of course, my life insurance is going to go to the beneficiaries. So in that case, I may not need anything. Or if I do, I need a very simple will saying, hey, if there is something else out there that I wasn't aware of, or maybe I inherited something that I didn't know of, that simple will would just instruct that those items go to my children. So that's phase 2 of planning in my mind, or in my conception. And that is, do I need a will? Do I need a trust? Do I need neither of those things, or a combo or a hybrid of those things, in order to kind of tidy up where everything would go upon my death? The next phase of planning, I guess I coin it as advanced planning, but really 90% of us have issues in our lives that would trigger some sort of advanced planning. Advanced planning includes business succession planning. I'm a business owner. If you have any interest in a business, you probably need to take a little closer look than just a will or a trust or transfer plan. If I have any special needs children or grandchildren, I need to pay attention to that kind of planning. If I hold my wealth in things like rental properties or things that increase liability risk, I may need to do some planning to manage those risks that may exceed the need for just basic insurances or even umbrella coverages. So those are the kind of things that trigger maybe advanced planning, but the number one thing that would trigger what I term the third phase of planning is asset protection planning. What is asset protection planning? Surprisingly, people, more of us need it, or at least need to know about it than we think. Do we want to protect our assets from liability, from people suing us? Absolutely. But the number one drain of our assets in our retirement will be long-term care costs. And just to put a bow on that, let's look at it statistically. Right now, 12 million people in the US receive long-term care services. And long-term care is defined as the assistance with an activity of daily living. It could be bathing, dressing, food preparation, or it could be as simple as, hey, I can't drive anymore. My eyesight's not very good, or my memory is not getting me from point A to point B in a reliable manner. So 12 million of us receive long-term care at this point. As the baby boomers age into that phase in life, 72% of them will require long-term care. That means that we're going to be asking a system that currently serves 12 million people to serve 50 million people. That statistic right there tells me that she who plans the best will have the best options when that time comes. So that's why asset protection planning is just so critical. And what we need to know before we even begin that kind of planning is, what does care cost? And I have these statistics, and it seems like every 6 months I need to update these, because long-term care cost is outpacing inflation significantly. It's outpacing our plans significantly. Surprisingly, the most expensive care is in-home care. And I have never had a client that comes in saying, hey, I'd like you to put me a plan together that sends me straight to the nursing home. Everyone wants to stay at home. I want to stay at home. How can I figure out how to afford that type of care and plan for that type of care? Even if I don't want to leave a legacy to my next generation, maybe I conceive of, my last day will be the day I spend my last dollar. Long-term care costs make you think that, man, I might have more days than dollars if I need to consume that kind of care. So when you think about it, once you know the cost of care and you model that through inflationary, then you look at the statistics. The average person spends 2 years and 5 months receiving skilled nursing care. That statistic's important because very rarely do you go from needing zero care to the next day finding yourself in a skilled nursing facility. Very often you are consuming care along the way. Now, it does happen. There are catastrophic car accidents. There are strokes that come out of the blue. But normally the continuum of care, or the progression of care, starts you at home, maybe moves you to independent living. You might find yourself in assisted living for a while. Before then, you would need that high level of skilled nursing care. So what is asset protection planning going to do for us in that way? We have to figure out, how are we going to pay for that care? And the goal is to cash flow it such that we have enough cash coming in on a monthly basis that we do not have to dip in to our asset pool in order to fund that care. The hard part is we're not raising money at the time that we need care. We're not employable. We're probably not insurable at that point. So that's why the sooner we can begin planning a cash flow model for care, the better. And how do we do that? We look at long-term care insurances. Now, there are some people that were already into our care journey. We may not be able to be underwritten. There are many reasons that traditional long-term care insurance policies are just not attractive. There are I've got a lot of clients right now who we are working with their Genworth policies. They've gotten letters saying, hey, this policy that you've paid into for the last 35 years is now not able to deliver on its promises. And so we're going to raise your premiums, or you can take a lump sum. So some of these policies are very unreliable. And if that is happening now, I can't even conceive of what's happening in the next 20 years with those kinds of policies. However, I have had the privilege of working with a few financial planners that sometimes my clients bring me and they say, hey, my financial guy has a great plan where they have investment type products that will enable you to keep investing and grow your investment, but that they're earmarked, those dollars are earmarked for potential care dollars. So it's really important that as we think about insuring that portion of our life, that we work with a financial planner in conjunction with that elder law planner or that estate planner that you may have, because they have to talk about this. They can't do their planning in a vacuum, because these plans have to work together. They have to sing together. There are also long-term care insurance benefits that are provided through Medicaid programs and Medicare programs. A lot of people hear the word Medicaid and they think that Medicaid is for low-income, no-asset individuals. They fail to appreciate that for long-term care Medicaid, those insurance benefits are available regardless of income and regardless of assets. That there are specific buckets of long-term care insurance money that are available for people that would otherwise not qualify for a low income or low asset program. Because it is in the best interest of us to have that long-term care paid for. So we have federal and state rules that allow us to do that. We also have some waiver programs here in Indiana that will pay for in-home care. And because that is overwhelmingly the desire of everyone. Can I just have some care in my home? I don't want to live in an assisted living facility. I would like to stay at home, but I do need a boost. I do need a little bit of help. Also for veterans or veteran spouses, there are potential VA benefits available too. And those, if you are a veteran or a spouse of a veteran, those benefits are very attractive. So if that's something, even if you don't need care yet, you may want to just get a consultation as to what might be available there, because there's a little bit of pre-work that you have to do for that to get yourself set up. But it's good to at least investigate what might be available. And then there are various asset preservation strategies that when you plan ahead and you may couple long-term care insurance and Medicare, Medicaid long-term care insurance and strategies, you can win this battle. You can get what you need. So you just have to figure out what kind of category are you in. Anytime we're talking about asset preservation, there's two types of clients that walk through the front door. There's the client that is in crisis, have a medical event right now, or we have a diagnosis that we know is going to generate a medical event real soon. Or we have a pre-planning client that comes in and says, hey, I'm starting to put all these phases of planning together, and I'd like to learn about what this third phase, asset protection, is all about. There are different approaches for each of those types of clients. Let's first talk about the pre-planning client, the client who has the privilege of time and no crisis, and we can really think through some of our options. Normally, we steer those folks into what's called an asset protection trust. An asset protection trust is an irrevocable trust instrument that allows us to place assets in that trust. If those assets stay in that trust for 5 years, none of those assets then are exposed to long-term care spin down. If you're a veteran or spouse of a veteran during wartime, that 5-year look back may be cut down to a 3-year look back. So like I said, there's some VA benefits out there that are really significant. You just have to kind of see where you stand. But if we can do pre-planning and we have the time to do that, we have the runway to do that, we can absolutely preserve 100% of the assets from long-term care spin down, depending on the situation. So that's worth just educating yourself about at a deeper level. Just to kind of tweak your curiosity, I mentioned an asset protection trust. A lot of folks think, oh, if you're going to put me into an irrevocable trust, I'm not really interested in that because I don't want to be divested of my assets. I still want to control my investments. I still want to have access to my funds. So when we have that kind of conversation, I like throwing up this diagram of this trust, because if I'm going to create this irrevocable trust, I'm the grantor, I'm the one in the red rectangle, and I put all of my assets in the blue circle inside my trust. I can't directly reach in and get those assets back. That's true. But my trustee, who's going to be my children, they can reach into the trust and distribute it to the purple star people, the lifetime beneficiaries, who are my children. And then my children can cure that transfer back to me. So alas, I can get my money back out of there if I need that, if I need those kinds of assets. The other thing is, if I put assets into the trust and those assets are generating income, I'm entitled to that income directly. So if I have 5 rental properties and a stock portfolio that generates $1,500 a month in dividends, I'm entitled to all that rental income and those stock dividends. So there are ways to skin that asset preservation cat, even with an irrevocable trust. And it's worth kind of diving into that. It's a little bit beyond, I could probably do an hour just on this trust. So just wanted to kind of give you some issues to spot. But what if we don't have the privilege of pre-planning, the extra 3 or 5 years? What if we need care right now? There is an overwhelming misunderstanding out there that once you need care right now, you have to spend all of your money before you are entitled to any sort of help paying for that care. And if I leave you with one message, I want to leave you with, that's just not true. If there is a couple and one of the spouses needs long-term care, we can preserve 100% of the assets back to the spouse that does not need care. That's called the spousal impoverishment law. The concept behind that is the United States government would rather assist the sick spouse in paying for their care than require the healthy spouse to spend down the couple's entire life savings, because this healthy spouse statistically will live longer and she will consume more needs. So if she is impoverished because she's paid for her husband's care, she will need healthcare insurance herself, but she'll need housing assistance, transportation assistance, food assistance. She will cost a lot more. So that's why those dollars are available for that first sick spouse. They will be covered for long-term care. Let's say there's only one person. The single preservation rules permit us to preserve at least 50, usually anywhere between 50 and 80% of the assets that remain. What's the concept behind that? Well, the concept there is the entire philosophy for long-term care is to try to rehabilitate the person receiving that care to get back into the community, to get back home, to get back to a more independent, autonomous lifestyle. So if I have a stroke and I need skilled nursing for 6 to 8 months while I rehabilitate, and I have to private pay for that year's worth of rehabilitation, I may not have enough money left to go back home and to live. So now I'm going to be a resident of a skilled nursing facility when I may not even need that level of care anymore, but I was artificially impoverished trying to even get back home. That's why the single preservation law allows us to preserve at least half of our asset vote. So I just want us to throw off or resist any of that kind of, we used to call it beauty shop advice. Now it's probably Starbucks advice where somebody says, oh, yeah, my mom went in a nursing home. She had to spend every single dollar before she could get help paying for it. That's not true. If I can leave you all with a couple more pieces of sage advice, a lot of folks believe that, or they've heard through the grapevine, beauty shop advice, that if I give away my assets to my kids, then I can become eligible for long-term care benefit. Yes, that may be true if you give it away and 5 years lapse. But the problem is, what happens if you need some of that money back? Or if you need to cure those gifts because you need care before 5 years elapse? Perfect example. I have $100,000 and I'm going to do some DIY asset preservation. I'm going to give it to my daughter and say, hey, honey, you keep that in an account, just your name for me. If I need anything, I'll come back at you. She wants to help me. She's going to preserve that money for me. Everything is great. I come back a couple years later and say, hey, I need 10,000. I got to replace my furnace. And she says, I'm sorry, you're going to have to go talk to my ex-husband. He took all of your money. DIY gifting doesn't have all of the protections that a robust, holistic asset protection plan would have. Imagine that situation if my daughter predeceased me, that my money's no longer mine, it belongs to her estate and consequently her heirs of her estate. What if my daughter has creditors? Those creditors don't care that I funded that account. They care that her social security number is on that account and she owes them money. What if she gets in a car accident and she's sued and she has to pay some sort of judgment? That money, again, in the eyes of the law is hers. It's no longer mine. What if she has financial issues and with her best intentions doesn't mean to dip into my account, but she has to? The other really unintended consequence of gifting that a lot of people run into, they had no idea was coming, is they will give their home to, or put their daughter on their home title, or they'll just sign over their house to their daughter. They're going to try to bypass probate because it's going to transfer upon their death. And they're going to try to make sure that their house doesn't get taken if they need long-term care. The issue there is, let's say I bought my house back in the 70s for $20,000. If I sell my house today, I could sell it for $120,000. If I give it to my daughter, when she goes to sell it, she will pay capital gains on the difference between what she sells it for and the 20. I need to find a way to get her that step up in basis so that she does not have to pay capital gains. If I just give it to her outright, there's going to be tax situations. If I give it to her as part of an asset protection plan, there will be no tax implications under current legislation. So as I started the program, as I opened the program, I mentioned that I learned the hard way that this is not, what we're trying to accomplish is not just estate planning. It truly is a life care plan. And what drives that? The social medical piece drives that. So as we begin to plan, or as you begin to start planning with your loved ones, you've got to look at the social medical clues. When is it time to begin to conquer these questions and to start having these conversations? There are certain warning signs. And a lot of times these warning signs, you get the first glimpse of them, maybe over the holidays when you visit your folks or something like that. But, pay attention to hygiene. Hygiene begins to go when we begin to hurt, or we begin to need care, or when we begin to have cognitive issues. There are mobility issues that are evident when you walk into mom or dad's house and they've kind of moved the furniture toward the middle of the room so they can make it to the restroom. The one I noticed when I was helping my grandparents was just some unexplained dents and scratches on the car. You know, that showed me that, hey, we might have some eyesight issues. We might have some other kinds of mobility issues that maybe we need to talk about driving. So these are the kinds of warning signs that we're going to take a look at to say, when do we need to begin some asset protection planning or some pre-planning? And yes, they do sometimes require tough conversations. And hopefully this kind of program today will prompt some of those hard conversations with you, with your own family, with your spouse. They're tough, but I'm telling you what, when things get planned and taken care of, it's a peace of mind that really is invaluable. Thank you very much for listening today. If you have any questions that you've been saving up, now's the time.
One question we did have pop up in the chat is, when did the single person preservation rule come into existence?
Sure, it was part of it was part of OBRA 93. So 1993, when the Omnibus Deficit Reduction Act was enacted, that's when we could start doing some preservation techniques. Now that OBRA 93 has been amended and added to over the course of the years to give us the current rules, 50%, 80%, but that's when the concepts became, first got on the books.
Great. While there's more questions being gathered, let me jump in on the, and I'm going to build on something Lisa just talked about in terms of tough conversations. Throughout Lisa's presentation, and it was a great set of information, several times she referred to your representative. There were different titles. It might be the administrator, it might be the guardian, might be a trustee, various words, executor of your estate, those kinds of words. Let me remind you that human nature being what it is, there's certain questions that just naturally pop up at that point as to who do I pick? Who should be representing me? Well, questions like, well, who deserves it? Who should be appointed as my representative? Or who would be upset if I didn't appoint him or her? And so should I be fair, and should I be equitable in terms of who I put in a position to deal with my person or my estate? And invariably in these complex times, are there multiple players involved? And by that, I mean multiple children, stepchildren, more importantly, other loved ones or people important to you. And so who are all these people that come into play on the potential for the decisions? Well, there's only one question that really you should focus upon when you're talking about who should be my representative. And that is just simply, who is competent to do it? Who's capable to do it? Who's competent to do it? Now, that leads to one of the very tough conversations Lisa just mentioned a moment or two ago. And in the perfect world, you say, okay, I've had this thoughtful, reflective analysis of who in my sphere of influence, who is the person who should be my representative. And I think through and put in my documents him or her. In the perfect world, you now have a frank conversation with the relevant folks, with your children, stepchildren, others, in advance to try to avoid hurt feelings or disagreements when your appointment becomes relevant. I readily admit, and I think Lisa would agree, those kind of conversations happen in the perfect world. They're not sometimes easy conversations. I'm picking John, not Mary, but to do them in advance and to recognize that they're going to be tough conversations, but to do them in advance and not surprise anybody when all of a sudden your documents are opened up or your lawyer shares the documents and someone's expectation then is not met as to who's going to be mom or dad's representative. It's far better to have a conversation which might be a little uncomfortable, might be a little tough, but nevertheless, have it up front if you can bring yourself to make that happen. That's easy advice to give. It's tough advice to live sometime, but nevertheless, it's important. So with that, Lisa, let me
Yeah,
again,
I
defer
would.
back. I know there's some
Yeah,
questions.
I would echo that absolutely. And here's a few resources to have that conversation. I
Great.
will have clients call me and say, hey, I'm bringing the kids in today. Here's what I want to pick, and I need you to help me. And that's
Perfect.
absolutely within the bounds. When you're consuming legal services or whatever services you're consuming, you're absolutely permitted to ask for that kind of help. And that is appropriate and smart. I think you should do it. And if that's, in the middle of a law office is not where you would like, perhaps if you have a trusted faith advisor, have that conversation there. They are hard conversations, Greg, but I will tell you, transparency solves so many problems down the road. It's better to rip off the Band-Aid now while you can still have input, talk about it, than the fights that end up in the courtroom later.
We've had about 3 questions pop up, so I won't do them in rapid fire because I know I definitely forget those. So the first one is there ever a good time for a guardianship?
Yes, there actually are. Well, I don't know that I would say good times. Obviously, if we need a guardianship, we're in some distress just based on those circumstances. If we need one, there's an issue. The advanced directives, while they can and they should be as robust as humanly possible, I will tell you there's at least one circumstance where even the best advanced directive is not going to keep you out of guardianship court. And that is if the principal, if I absolutely refuse to go to skilled nursing care or to memory care, if I absolutely refuse, there is no memory care facility or skilled nursing facility on the planet that is going to take me against my will. They're going to require law enforcement to tell me that I am a danger to myself or others, or they're going to require a court order. You're going to need a guardianship in that situation. The other situation where a guardianship, you may be able to use it as a shield rather than a sword, and that is, let's say you're the power of attorney and you have some, mom or dad has lost capacity and we have some siblings that are bubbling up and there's a fight on the horizon. You may want to go down to guardianship court and have your power of attorney endorsed by the guardianship judge. The statute in Indiana gives a lineup or a priority of who's presumed the best guardian. The power of attorney was chosen while the people still had capacity and was not under influence. Power of attorney would be named as the guardian. So if I have power of attorney and I'm feeling shaky with my siblings and I sense a storm brewing, I might consider guardianship then.
The second question is asking, what is your fee to execute a trust after death?
Good question. And actually, let me answer even more than you just asked. Like I said, as a consumer of legal services, you should ask how much you're going to get charged. And more importantly, you should ask how you're going to be charged. Typically, lawyers charge in one of a few ways. Commonly, they charge by the hour or they charge by a flat fee. Now, in some instances, an attorney can charge what's called a contingency fee, meaning if they recover money for you, they're entitled to a percentage of that money. That's very rare in any sort of probate administration, guardianship, estate planning. If a contingency fee agreement is being discussed at that point, you will want to get a second opinion. If a lawyer is going to charge you a flat fee, you will want to have in that retention agreement, in that contract that you have with the lawyer, you will want to have a good description of the scope of the services that are covered by that flat fee, so that there's not disagreement later that you've paid for something that the attorney now does not believe they should be doing for you. Hourly is just like it sounds. That means when you call the lawyer, they turn on the clock. So in many instances, a flat fee is very desirable because you can budget. You can kind of plan for what that's going to cost so long as you have a good understanding of the scope. So first of all, be very knowledgeable about how you're being charged. Now, I will tell you, for most plans, my firm charges a flat fee, and we charge anywhere. So a set of advanced directives, I believe, is $450 maybe. Now that, I don't know where we stand in the market. We haven't secret shopped for maybe ever, I don't even know. So I don't know where we stand, but I have no problem sharing mine. Advanced directives about $450. A will-based plan is anywhere between $900 and $1,200, depending on complexity. Are we doing transfer on death deeds? Are we doing advanced directives with it? Those kinds of things. A revocable trust, that trust that avoids probate, that's usually anywhere between $2,500 and $4,500. And that's when I was talking to you before about how to best spend your money. Is if $4,500 for a trust right now blanches us, but if it goes down to probate and it's going to be $9,500, are those good dollars spent? You have to know in order to do the cost benefit. So you're absolutely entitled to ask someone to walk you through that. If we're doing asset protection, an asset protection trust, that's anywhere from $4,500 to $7,500, depending on how much we have to fund into that trust. Do we have to do 7 deeds for rental properties or assignments of LLC interests, those kinds of things. I think you also need to be aware that if you or your family are in crisis and you come in a crisis mode and need to try to do asset preservation, either through spousal impoverishment or single preservation rules, that crisis plan usually is anywhere between $6,500 and $9,500. So it runs the gamut. I hope that answered your question. And then we do at Applegate and Dillman, we do a program. We're the only law firm in the country or in the state that does what's called life care planning, where you pay an upfront fee that covers that whole gamut. So anywhere between 15 and 20,000 will do all of the advanced directives, trust work, crisis work, and we revisit it every year with you. Plus, there are nurses on staff that help with any care meetings. We go to the home to evaluate for fall risks, any sort of remodels that need to be done. So it really does, it's soup to nuts. You can consume those services anywhere along that continuum, and I'm just not sure what other prices run in the market.
And then the next question we have is asking if it matters if your representative is not familiar with any Indiana law and doesn't live in Indiana.
Lisa, let me jump in and take that.
I was going to say, Greg, Tom.
Yeah, it doesn't matter. Whoever's competent, that should be your selection. That person can always hire somebody competent, smart like Lisa, to bring them up to speed on the nuances of Indiana law, or the fact that they don't live in Indiana should not be any impediment in this day and age. Competency is king. Don't worry about, said differently, don't pick somebody because they happen to be convenient. Because if convenience was the most important thing, well, okay, but competency is more important. Trumps convenience 100% of the time.
Yeah. Let me piggyback on that. Even used to 3 years ago, there used to be this feeling that my healthcare power probably should be close, just in case. The pandemic set all that on its ear as well. I participated this morning in a care meeting with my elder care coordinators, my nurse who's on staff, and a life care client. We all participated by Zoom with their kid in Chicago and their kid in Seattle. And it was the most productive, collaborative meeting you would believe. And they're the healthcare representatives. So competence is king. That's the tagline.
And let me answer the question you didn't ask, which is, should my healthcare representative be the same person as my trustee on my stuff, my financial stuff? it doesn't necessarily have to be the same person, but again, it should be a competent person in each case, and it doesn't have to be the same person because maybe somebody who's closer and who has the feel for what your desires would be from a healthcare perspective, that may be one person. And the person that's got the competency, that's got the ability and the time and the background to be able to handle your financial affairs, maybe that's somebody else. And that's okay. Don't feel, if you've been lucky enough to have somebody like Lisa advising you, she will have told you to do that because, Mary is really good with your stuff, but Benny is the person that understands your head and understands your health and is closest to you in a physical sense. And so make those appointments appropriately, make sure it's the right person to do the job.
Okay, looks like that is it for questions. So Mike, I will go ahead and send it over to you to, looks like, close us out.
Okay, well, thank you, Lisa and Greg. I just can't tell you how valuable I feel like this information, is to everybody. And, the three takeaways I take from this is one, plan ahead. Two, ask tough questions. And that's not just questions with your family, but that's tough questions with your respective attorney or whoever that may be, just trying to uncover all of the information that you need to know to make these kind of what could be life-changing decisions, and then be very transparent. I just can't overstate after hearing all of this, is that the last thing you want to happen after we pass is for your heirs to be upset with things that maybe they had no idea what was going on. So great presentation, great information. I hope everybody on the call was able to take something away from this, as I'm sure you can. This is one of the things that the Always United group of United Way has really tried hard to do over the last couple of years is come up with webinars like this, which have to do with Social Security and Medicare and long-term care, aging in place, and then like today's presentation. And we want to continue to do that in the future. But I would encourage all of you, if you have any questions, let us know. If you have any recommendations on other topics that kind of fall into the decisions that we have to make when we reach this point in life, we would be happy to try to accommodate that too. So thanks again, everybody, for being on the call, and Lisa and Gregory for your information. So appreciate it very much. Have a good day. Thanks.
Really helpful. Thank you so much.
Thank you.